Lisa tugged lightly at my sleeve beside my father's grave. Mom, I left my coat inside. The last week of March had brought a cutting wind across the cemetery. Lisa had tried not to complain. My mother had already corrected her twice that morning, once when Lisa asked where she should stand, and again when she whispered that her fingers were numb. A funeral is not the place to make things about yourself, Linda had said, softly enough that most people nearby could pretend they had not heard. I told Lisa to stay beside the car with the other mourners and went back into Dad's house alone. Condolence cards covered the piano. Coffee cooled beside slices of cake no one had touched. The room still smelled faintly of his cedar aftershave, and for one dangerous second, I expected to hear him calling from his study. Then I passed the kitchen. We can't let Megan's adopted daughter inherit any part of the family's $33 million estate, my mother said through the partly closed door. I stopped before my heel touched the next floorboard. Paul answered in the careful voice he used whenever he wanted to participate in something ugly without sounding responsible for it. The 2017 trust never named her. My sister Lauren gave a short breath of impatience. That's why we use it. There was a rustle, then the sound of her placing a call on speaker. I heard it ring once. Elliot, Lauren said, use the old trust and make the 2025 amendment disappear. I pressed one hand against the wall. Lauren lowered her voice, but not enough. Help us, and you'll never have to work another day. My father had been buried less than an hour earlier, and they were already discussing how to erase the granddaughter who had spent every Thursday afternoon beside him at the old freight yard. I did not open the kitchen door. I did not scream. I took Lisa's coat from the hall closet, walked back outside, and drove my daughter home. Before I tell you what happened 1 week later, tell me where you are listening from, stay with us to the end, and please subscribe to the channel so you do not miss what this family discovered when their plan began to collapse. Lisa waited until we had passed the cemetery gates before she looked at me. She had put on the coat, but she still held the front closed because the zipper had caught in the lining. Your hand is shaking, she said. I tightened my fingers around the steering wheel. It's been a difficult day. That isn't what I asked. At 15, Lisa had a way of making dishonesty feel childish. She had learned that adults often hid decisions behind gentle voices, and she listened closely to what people avoided. I kept my eyes on the road. I heard something inside. I need to understand it before I explain it to you. Was it about Grandpa? Yes. Was it about me? The answer lodged behind my teeth. I wanted to tell her everything, but all I could hear was my mother saying adopted daughter, as if Lisa were a category on a form instead of the child who had sat beside Dad through 6 months of chemotherapy, arguing with him over whether the first Langley warehouse opened in 1971 or 1972. I'm not going to lie to you, I said. It involves you. But I need a few hours before I can tell you what it means. Lisa looked through the passenger window. Bare trees slid past us in gray rows. Grandma said I should not make today about myself. I heard her. You weren't trying to. She nodded once. Okay. That controlled answer hurt more than anger would have. I had spent years repairing each insult after we left and calling that protection. Driving home from my father's funeral, I was no longer certain the word fit. I made soup neither of us ate. Lisa went upstairs with a book and closed her door without slamming it, which was how I knew she was truly upset. I waited until I heard the water running before I went to the locked drawer beneath my desk. Dad had given me the blue folder 11 months earlier. We had been sitting in his office at Langley Freight and Storage while rain struck the warehouse windows. He had looked thinner then, though he still refused help standing. If anyone tells you Lisa's name is not in my final documents, do not argue with them, he had said. Call the number inside. I had asked whether he expected trouble. I expect people to become very clear when money removes the need to pretend. That was all he told me. Inside the folder was a single page bearing the name Harbor Fiduciary Trust Company, a custodial acknowledgement number, and the contact information for Claire Holloway. There was no copy of the trust, no secret letter, and no explanation of what Lisa would receive. Beneath Dad's signature was one handwritten instruction: do not sign a family settlement before Claire reviews it. I called the number at 9:17 that evening. A woman answered on the fourth ring. Claire Holloway. My name is Megan Calder. Edmund Langley gave me your number. The silence on the other end changed. Is Edmund all right? He was buried today. I'm sorry. I read her the acknowledgement number. I expected confirmation that the folder gave me some authority. Claire gave me none. That number tells us Harbor acknowledged receiving something from your father, she said. It does not give you control of the trust, and it is not proof by itself of what the final document says. I heard my family discussing a 2025 amendment. Tell me exactly what you heard. Do not interpret it yet. I described the kitchen, where each person had stood as far as I could tell from their voices, and Lauren's words to Elliot. Claire asked whether the call had been on speaker and whether I had heard Elliot respond. I heard the phone ring and Lauren speaking. I did not hear his answer. Good. Write that precisely. Do not improve the facts because you are frightened. Her firmness steadied me. She instructed me to write a contemporaneous memorandum while every detail was fresh. I noted the time I entered the house, the phrases I remembered, the location of the kitchen door, and the moment I left. I also wrote what I had not seen and could not confirm. Claire asked me to photograph the folder, the acknowledgement number, and Dad's handwritten instruction. Then she explained the next steps in plain language. She would send preservation notices that night to Elliot, Linda, Lauren, Harbor, and Langley Riverfront Holdings. The notices would require them to preserve emails, drafts, billing records, trust documents, messages, and transfer instructions. In the morning, she would prepare a petition asking the probate court for instructions and temporary protection against any rushed transfer of trust assets. You are not stopping the trust tonight, she said. You are creating a record before anyone can claim nothing happened. Upstairs, a floorboard creaked. I lowered my voice. My daughter knows I heard something. Tell her only what you can tell truthfully, without placing the case on her shoulders. She is 15, not your investigator. My phone vibrated while we were still speaking. A message from Lauren appeared. Family meeting next Friday at 10. Elliot has prepared a family resolution so we can settle Dad's estate peacefully. Bring Lisa's adoption papers and be ready to sign. I read it aloud. Claire was quiet for a moment. Do not answer tonight. They think I heard nothing. Then let them keep thinking that. I looked toward the stairs, where Lisa stood in the dim hallway wearing one of Dad's old freight yard caps. Her eyes moved from my phone to the blue folder on the desk. Claire's voice came through the speaker, calm and exact. From now on, do not try to make them confess. Let them believe you still do not know what they are racing to do. Lisa stood halfway down the stairs, wearing one of Grandpa's old freight yard caps. The navy fabric had faded almost gray, and the embroidered Langley logo sat crooked above her left eyebrow. Her eyes moved from my phone to the blue folder on my desk. Is that what he gave you last year? I closed the folder without hiding it. Yes. And the meeting is about me. It may affect you. That means yes. I could have told her what I had heard in the kitchen. Part of me wanted to put every ugly word into the open so she would understand why my hands had shaken in the car. Claire's warning stopped me. Lisa was my daughter, not my witness, and Lauren's plan would not become her burden simply because it had been built around her name. I will tell you everything when I know what is fact and what is only something they are trying to do, I said. Until then, I need you to trust that I'm not signing anything. Lisa adjusted the cap. People usually say, trust me, when they want the other person to stop asking questions. I know. She studied my face, as if deciding whether that answer deserved anything more. Then she walked back upstairs, leaving me with the folder and the first memories of how hard she had once worked to decide whether I was worth trusting. I entered the older child adoption program in the spring of 2018. By then, I had already ended an engagement that everyone in my family considered sensible. Daniel had wanted children, until I explained that I planned to adopt an older child, someone who might remember other homes and promises that had failed. "Why make it harder than it has to be?" he asked. He wanted a younger child we could, in his words, raise properly from the beginning. He never said damaged, but the word lived beneath the sentence. I returned his ring 2 weeks later. Linda called it impulsive. Paul said I was sacrificing a stable future for a child I had not met, and Lauren accused me of trying to prove I was more compassionate than everyone else. Dad asked one question: "Are you certain you want to be a parent, or do you want to be thanked for becoming one?" I told him I wanted to be a parent. "Then choose a child who is allowed to be angry with you." Lisa was 7 when we met in a county family services room with plastic chairs and incomplete puzzles. She neither smiled nor looked frightened. She looked practiced, as if she had already watched too many hopeful adults enter and leave. I brought no gift. The caseworker suggested a small gift. I brought only a deck of cards because Lisa's file said she liked games, and I did not want our first meeting shaped by what I gave her. She asked whether I always followed instructions. "Only the useful ones." That sounds like something adults say when they want to break rules. It probably is. She beat me at 3 hands of gin rummy and accused me of letting her win. By our 3rd supervised visit, Lisa had asked how many children I had met before her and whether my former fiancé had left because of her. "You didn't exist in my life when that relationship ended," I said. "That isn't an answer." I told her I had wanted to adopt an older child, and he had not. "He was probably smart," she said, staring at her cards. "About some things. You could still change your mind." "So could you." That unsettled her, more than a promise would have. I arrived every Tuesday and Saturday for 4 months, changing my work schedule rather than asking Lisa to excuse me for being late. I did not promise we would become a family before either of us knew whether we could live together. During our first overnight visit, she kept her backpack beside the bed and carried it into the bathroom the next morning. I never asked her to unpack it. By the 3rd overnight, she left it near the bedroom door. 2 months later, she forgot it in the car. The adoption became final in October 2019, 6 weeks after Lisa turned 8. In court, she called me Megan and asked whether the judge could change his mind later. The judge told her the order was permanent. Lisa looked at me instead of him. "People say permanent when they mean until something becomes difficult." I told her, "Then you can watch what I do when it becomes difficult." Linda and Paul attended dinner. Lauren arrived late with a dress Lisa had not asked for. After the photographs, Linda told me in the kitchen that I had chosen a child with too much history. "You could have adopted a baby," she said. "A baby would have grown into the family naturally." Paul tried to soften it. "Your mother only means this will be complicated." Lisa was close enough that I could not be certain she missed every word. Dad arrived carrying a dented metal lunchbox from the freight yard. He placed it in front of Lisa and said, "It belonged to a woman named Marlene Tate, first female dispatcher I ever hired. She argued with me every day for 22 years. Lisa opened the empty lunchbox. "Why are you giving me someone else's stuff?" "Because you asked last week whether women worked at the yard when I started, and everyone else at this table has heard the answer too many times to care." He sat beside her and told her Marlene had once redirected 12 trucks during a flood because Dad refused to believe the river would rise. Lisa interrupted twice to ask why he had ignored the weather report. Dad grinned. "Finally, someone in this family is interested in the correct part of the story." After that, Thursdays belonged to them. He took her through the old warehouses and introduced her to retired employees who still stopped by for coffee. Lisa learned names because names proved the stories belonged to real people. She remembered the loading dock that collapsed in 1986, the first refrigerated driver, and why Dad kept a scratched brass plaque near dispatch. The more she learned, the more my family treated her knowledge as imitation. At a summer cookout 2 years before Dad died, Lauren pointed toward an elderly man near the fence and asked whether anyone remembered who he was. Someone from accounting? She guessed. Lisa answered before Dad could. Walter Bell. He ran night dispatch for 17 years. Grandpa fired him for 3 days in 1994, then hired him back because nobody else understood the route books. Walter laughed. That girl remembers better than Edmund. Lauren's smile tightened. She's been studying. Linda handed Lisa a stack of empty plates. Knowing stories isn't the same as growing up inside them. Lisa carried the plates to the kitchen without answering. Later, she told me she did not care what Linda thought. Lisa protected herself by collecting proof that she belonged, then pretending it meant nothing when my family moved the standard again. The night after Dad's funeral, I found her at the kitchen table with the freight yard cap beside her and an old company directory open in front of her. She had circled Walter Bell's name years earlier in blue ink. Is Friday's meeting about what Grandpa left me? She asked. I sat across from her. Yes. How much? I don't know the final amount, and I won't guess. Do they think I shouldn't get it? They are making decisions that could affect your rights. Claire is finding out what they have done. Lisa's jaw tightened. Did Grandma say I'm not real family? I could not answer that without telling her about the kitchen, and I would not give Lauren's words more power before I understood the plan behind them. I'm not ready to repeat everything I heard, I said. Not because I don't trust you, but because I refuse to make you carry an investigation that belongs to adults. She looked down at the directory. Adults always say something belongs to them when they don't want kids to know they're talking about us. You're right to question that. I reached across the table but stopped before touching her hand. Lisa closed the directory herself and slid it away. I can promise you one thing, I said. I will not sign anything that changes your rights, gives away something Grandpa left you, or treats your place in this family as something they get to negotiate. Lisa turned the old cap between her hands. Her anger had not disappeared, but something steadier settled beneath it. If they're going to test whether I belong in this family again, she said, this time I want to know who wrote the test. Lisa's question followed me into the next morning. Who had written the test she had spent years trying to pass? By 9, I was sitting across from Claire Holloway, in a narrow conference room above a pharmacy downtown. The blue folder lay between us. In daylight, it looked almost disappointing, too thin to protect anyone from a family willing to lie for $33 million. Claire opened it and removed the single acknowledgement page. This does not contain the amendment, she said. It only proves Harbor Fiduciary received a sealed document connected to your father's trust. So we still don't know what is inside. We know enough to ask the court to preserve it and identify the governing document. We do not know enough to declare victory. She drew 3 boxes on a legal pad. In the first, she wrote Dad's name. In the second, Linda and Lauren. In the third, Harbor Fiduciary. Your father created a revocable living trust in 2017, she said. He remained the sole trustee while he was alive, which meant he controlled the assets and could amend the trust. That version named your mother and Lauren as successor co-trustees after his death. I looked at their names together. The arrangement explained why they had sounded so certain in the kitchen. Claire tapped the third box. The 2025 amendment appears to have replaced them with Harbor as sole successor trustee. Until we see the signed instrument, that remains a conclusion supported by the acknowledgement, not a fact we can present as settled. What happens if Elliot hides his copy? If Harbor received the second original, hiding one copy will not erase the other. Claire pointed to the acknowledgement. Dad had arranged the Harbor delivery himself after leaving Elliot's office, and the receipt named Dad as its only recipient. We could not assume Elliot knew the delivery had been completed. She called the number printed beneath the acknowledgement code and placed the phone on speaker. After identity checks and a transfer to Harbor's legal department, a trust officer named Miss Wanna Flee, Chen confirmed that a sealed duplicate original connected to Edmund Langley's trust was stored in their vault. Has administration begun? Claire asked. Not formally, Miss Chen said. We received notice of Mr. Langley's death yesterday, but we have not opened the full administration file. Given the dispute notice your office sent, No voluntary transfer or distribution will be processed, pending document verification and court instructions. Can you send us a copy today? No. We will preserve the sealed instrument and submit it through the appropriate court process or an authorized administration procedure. We cannot release it based only on a beneficiary's request. I felt relief and frustration at the same time. The document existed, but it was behind a door none of us could simply open. Claire thanked Miss Chen and ended the call. That answer helps us. Harbor is behaving like a fiduciary, not like someone taking sides. I took Lisa's adoption decree from my bag, along with the amended birth certificate issued after the adoption became final. Her legal name appeared in black type on both documents without a qualifying word beside it or a footnote explaining where she had come from. Claire copied them for the filing. These establish that she is your legal daughter. They do not tell us what Edmund left her, but they eliminate any argument that the name in the amendment refers to someone else. Claire had prepared a petition asking the probate division to identify the governing instrument, preserve the records, and stop any transfer until Harbor presented the sealed document. The filing did not accuse Elliot of accepting Lauren's offer. My memorandum established a dispute and stated plainly that I had not heard his answer. You heard Lauren make an offer, she reminded me. You did not hear his answer. We state exactly that. I signed the verification page. Claire then slid a retainer agreement across the table. The amount was $10,000. I had $34,000 in emergency savings, most of it built slowly after the adoption. That money represented a leaking roof, a broken car, or months without work if either Lisa or I became ill. Moving $10,000 out of it made my stomach tighten. Claire noticed. I will not tell you this will be cheap. If Harbor confirms the amendment and the court agrees the action protects a beneficiary, we can later ask whether reasonable fees should be advanced or allocated from the trust. There is no guarantee. I thought of the meeting Lauren had scheduled, and of Lisa sitting at the kitchen table with Grandpa's cat beside her. Then I authorized the transfer. By early afternoon, Claire had filed the petition, and Harbor confirmed a temporary administrative hold on voluntary transfers. No one had won. The assets simply could not be rushed out while the final document was being verified. The first response came from Elliot's office 3 hours later. He did not call. His staff uploaded a document packet in response to the preservation notice. It contained engagement records, older trust indexes, billing summaries, and copies of recent invoices connected to the Langley matter. Claire went through each page while I sat beside her, trying not to assign meaning to every highlighted line. Near the bottom of one invoice, she stopped. The client name was Bishop and Vale Events, Lauren's company. The description read Community Relations Consultation. Beneath it, the project reference named Langley Riverfront and Northbridge Urban Partners. Who is Northbridge? I asked. Claire searched Ohio business and property filings. Northbridge Urban Partners had acquired several riverfront parcels ending 2 blocks short of the freight yard. A city notice showed a rezoning vote scheduled for May, one that could sharply increase development values. Dad had once told me Northbridge was buying yesterday's land, before the city approved tomorrow's prices. The yard and warehouses made up most of his wealth. He had refused their offers because they saw empty land, where he saw a business people still depended on. Why would Lauren's event company bill Northbridge for community relations involving Dad's property? I asked. I don't know yet. Claire kept her eyes on the invoice. An invoice proves a connection, not an illegal agreement. We need the contract, payment records, and communications before we decide what it means. My phone rang before she finished. Lauren's name appeared on the screen. Claire shook her head, so I let the call go to voicemail. A minute later, an email arrived from Elliot's office with the subject Family Settlement Proposal. Lauren and Linda were copied. The agreement offered Lisa $250,000. In exchange, I would release every claim connected to Dad's trust, waive any challenge to the 2017 document, and agree that the payment did not constitute an admission that Lisa was a beneficiary. I read the final condition twice before looking at Claire. They want to pay her without admitting he left her anything. They want you to sign away whatever the sealed amendment says before anyone sees it. Can I refuse for Lisa? You can refuse to sign for yourself. You are her parent, but you cannot automatically bind a minor beneficiary when your own interests may also be affected. If this becomes a formal settlement dispute, the court may appoint someone independent to represent her. I thought of how often my family had spoken around Lisa, as if being her mother gave me the right to absorb every insult and make every decision alone. Even protection could become another way of silencing her if I was not careful. I closed the proposal and told Claire I would not sign it. She drafted a short response stating that I declined and that all communications should go through counsel. We did not mention Harbor's vault confirmation, the petition's filing details, or the Northbridge invoice. Lauren did not need to know how much we had learned. Claire placed the invoice beside the settlement and traced the Northbridge name with one finger. They are not only trying to get more money, she said. They need the right to sell something they have already promised to someone else. Claire's words stayed with me all the way home. My family was not only trying to take something from Lisa, they needed the power to sell something they had already promised to someone else. I had barely set my bag on the kitchen counter when the doorbell rang. Linda and Paul stood on the porch without coats, despite the cold, as if they had left in too much of a hurry to think about weather. My mother held a leather folder against her chest. Paul stood half a step behind her, wearing the expression he always used when he wanted me to believe he had only come to keep everyone calm. "We need to talk before lawyers turn this into something none of us can undo," Linda said. "You already have a lawyer. So do you, apparently. I should have left them outside. Instead, I stepped back because Lisa was upstairs, and I wanted control over where the conversation happened. I led them into the kitchen and remained standing. Linda placed the folder on the table. $250,000 is an extraordinarily generous offer for a child who was never born a Langley. I looked at her for several seconds. You haven't used the name Langley since you married Paul 40 years ago. Lauren has never used it at all. That is not the same. Why? Her lips tightened. Because we are Edmund's blood. There it was, stripped of all the careful language about tradition and order. My mother was not defending a surname. She was defending her right to decide which legal relationships counted when money was involved. Paul pulled out a chair but did not sit. "Megan, no one is saying Lisa means nothing to you. That is a very low standard for a family conversation." He exhaled through his nose. "Lauren's company is in serious trouble. If this sale falls apart, people could lose their jobs." The Northbridge invoice flashed through my mind. What sale? Linda turned toward him so sharply that he looked down at the table. Paul rubbed one hand over his jaw. "I'm not involved in the details. You knew enough to come here and ask me not to make Lauren bankrupt. We are asking you to be reasonable," Linda said. "Your father made changes late in life that disrupted years of planning. Lisa did not build that business. She did not grow up in it. She spent more time at the freight yard with Dad than Lauren did in the last 5 years. That does not make it hers. No, the trust does, if her name is in it." My mother's composure cracked for only a moment. "You have not even seen the amendment. Neither have you, apparently. Otherwise, you wouldn't be trying to pay me before Harbor opens it." A floorboard creaked in the hallway. I turned and saw Lisa near the bottom of the stairs. She wore jeans and one of Dad's old work shirts over a t-shirt. Her face had gone still in the way it did when anger arrived before she had decided what to do with it. Linda followed my gaze. "This is an adult conversation." Lisa came into the kitchen. "It's about buying me out of something Grandpa left me." "No one is buying you out," Paul said. "We are trying to avoid a long fight." "For $250,000. Linda pushed the folder toward me. "That amount could pay for college, a home and a stable future. Most children would be grateful." Lisa gave a humorless laugh. "Most children don't get offered money to agree they were never family." "Lisa," I said. not to silence her, but to keep the room from becoming the spectacle Linda wanted. She looked at me instead of my mother. "Don't tell me to calm down." I wasn't going to. Her eyes were bright, but she did not cry. "Then I want all of it. Every dollar Grandpa left. I want enough that she has to look at my name every time she opens a bank statement." Linda stared at her as if Lisa had finally confirmed every accusation she had ever made. I stepped between them. "You have every right to be angry. You do not have to be gracious about what they are doing. But I will not let their money become the only proof that you mattered to Grandpa." Lisa folded her arms. "That is easy for you to say when nobody is trying to pay you to disappear." The words landed because they were true. Before I could answer, my phone rang. Claire's name appeared on the screen. I told Linda and Paul the conversation was over. Linda gathered the folder but left the settlement proposal on the table, perhaps hoping the number would continue speaking after she left. Paul paused at the door. "Please don't destroy your sister's life over this," he said. I looked at the man who had helped raise me and wondered how many times he had confused, refusing to stop harm with causing it. "Lauren's life is being shaped by whatever she already agreed to," I said, "not by my refusal to sign." After they left, I answered Claire's call. The probate division had issued an interim preservation order. No one could sell or transfer the core trust assets. All relevant records had to be preserved. The judge had made no decision about whether the 2017 trust or the 2025 amendment controlled. "This is not a victory on the merits," Claire warned. "It only keeps the property in place while the documents are examined." The court had also appointed Jordan Price as Lisa's independent attorney, with authority to evaluate whether any proposed settlement protected her interests. Lisa heard the title and frowned. "Why do I need another adult deciding things for me?" "Jordan does not replace me as your mother," I said. "She makes sure no one, including me, signs away your legal rights because of pressure or because our interests stop matching. My interests match yours. I hope they usually do. The law should not have to rely only on hope." Jordan came to the house that afternoon. She was direct without being cold and explained that her conversations with Lisa would sometimes remain private from me. Then she asked me to leave the room. I did. For 40 minutes, I sat on the front steps while March wind moved through the bare maple branches. Every instinct in me wanted to know what Lisa was saying, whether she blamed me and whether she wanted the money. Letting another person hear her without me interpreting the answers felt less like losing control than admitting she had a voice separate from mine. Jordan left without revealing the conversation. "Lisa understands more than the adults around her assume," she said. "She is also carrying more than she should." That evening, Claire forwarded a letter from Elliot. He identified himself clearly as counsel for Linda and Lauren, not for the trust or harbor. The letter stated that the 2017 trust was the only controlling instrument currently presented by his clients, and requested that I reconsider settlement before further litigation depleted family assets. Claire highlighted 2 phrases. "Currently presented by his clients," she said over the phone. "He is not saying the amendment does not exist. He is not even saying the 2017 document is legally final. He is describing what Linda and Lauren have chosen to place in front of him." Why write it that way? Because every word matters to him. I read the letter again. Elliot had left himself a narrow space between what his clients wanted and what he was willing to state as fact. "I want to meet him." Claire was silent for a moment. "He may try to negotiate directly, provoke an admission, or learn what Jordan knows. I won't negotiate. I want him to understand that this cannot disappear quietly. Do not show him our filings beyond what has already been served. Do not tell him what Lisa said to Jordan. Do not threaten him, and do not promise him anything." Claire sent Elliot written consent for one direct meeting, limited to exchanging information. I was not authorized to negotiate or sign anything. Elliot agreed to meet after his office closed. At 7:30 the next evening, I entered the nearly empty building and followed him into a conference room overlooking downtown Riverton. He closed the door behind us without offering his hand. A draft settlement waited on the chair across from him, positioned exactly where he expected me to sit. The draft settlement waited on the chair across from Elliot Vance, as if he had already decided where I would sit and what I would sign. I left it there. Elliot removed his glasses, folded them once, and placed them beside a yellow legal pad. His office had emptied for the night, but the lights from downtown Riverton still reflected against the conference room windows. From 15 floors up, the streets looked orderly enough to make human choices seem smaller than they were. "Your mother and sister want to avoid litigation," he said. "They want to avoid the final document. They believe the 2017 trust reflects Edmund's long-term intentions. Then why are they offering Lisa money to waive a document they say does not matter?" His eyes shifted toward the settlement on the chair. "Because even weak claims can consume years and significant legal fees." I remained standing. "Is that what you think Lisa is making? A weak claim?" "I have not said that. You have written 3 pages asking me to sign it away." Elliot leaned back. He looked tired in a way expensive clothing could not hide. The collar of his shirt had softened, and faint shadows sat beneath his eyes. "Lisa has you," he said. "She has a stable home, education, medical care, and a parent who is clearly prepared to fight for her. This is not a child being left without support." The words were too polished to be spontaneous. He had repeated them to himself before offering them to me. "So that makes it acceptable to erase her?" "I did not use that word. My family did." He looked at me more carefully. "What exactly did you hear?" I remembered Claire's instructions. "Do not negotiate. Do not disclose more than necessary." I heard enough to know they expect you to treat the 2017 trust as controlling and keep the 2025 amendment from being considered. You did not hear my response. "No." "Then you do not know what I agreed to." "That is why I came." Elliot gestured toward the empty chair. I sat, but I moved the settlement onto the table between us instead of leaving it at my elbow. He opened the document to a marked page. "There are ways to increase the payment. If the concern is Lisa's future, I believe Linda and Lauren would consider a more substantial protected fund." "How substantial?" "That depends on whether everyone is prepared to end the dispute." "You are asking me to price my daughter's name before anyone opens the document bearing it." "I am asking whether certainty might serve her better than prolonged litigation." "Certainty for whom?" His jaw tightened. "For a 15-year-old who should not spend the next several years at the center of a family lawsuit." Lisa did not put herself at the center. The adults trying to remove her did. For the first time, Elliot looked away. I took a copy of Lisa's adoption decree from my bag and placed it on the table. I did not slide it toward him. He already understood what the document meant. "Harbor has confirmed the custodial file," I said. "The probate division has issued a preservation order. Jordan Price now represents Lisa independently. Whatever you believe you can settle in this room will not disappear because I sign my name." His gaze returned to mine. "Have you seen the amendment?" "No." "Then you do not know what it provides." "I know enough to understand that using the old trust will not end this quietly." A muscle moved beside his mouth. "You have no idea how expensive this could become." "I transferred $10,000 to Claire yesterday. I understand enough." "That is the beginning, not an estimate." "I did not come here because I think I can outspend my family." "Then why did you come?" I looked at the man who had prepared my father's documents. The man Lauren believed she could purchase before the dirt had settled over Dad's coffin. "I did not come here to ask you to save my daughter," I said. "Harbor has the file. The court has stopped the transfers. Lisa has her own lawyer. You are no longer the only person standing between that amendment and a locked drawer." Elliot's expression remained controlled, but his fingers closed around the edge of the legal pad. "I came to ask whether you still want to become the man my sister believes she bought." The word "bought" changed him. It was not dramatic. He did not confess, deny, or rise from his chair. He simply stopped touching the legal pad, and the silence afterward felt different from the pauses he had used to control the conversation. "Be careful," he said. Why? Accusing an attorney of accepting payment to conceal a document is serious. I did not accuse you of accepting anything. I repeated what Lauren believes. He studied me long enough that I heard the hum of the building's ventilation system. I touched the adoption decree. This is not a sentimental argument, Elliot. Lisa is my legal daughter. If her name is in Dad's final amendment, then removing it is not correcting an oversight. It is helping adults turn a mother and child relationship into a mistake they can erase when it becomes financially inconvenient. You are assuming motive. I heard the motive in my mother's voice. He stood and walked toward the window. Families settle inheritance disputes every day. Beneficiaries take less than they believe they deserve because certainty has value. That does not make every agreement immoral. No. But this agreement asks Lisa to accept money while stating that the payment does not acknowledge she was ever a beneficiary. They do not only want her share, they want control of the story. Elliot turned back. Suppose the amount were enough to guarantee her education, housing, and long-term security. Would you still refuse? Would they still insist she was never entitled to it? He did not answer. Then yes, I said. Because the right to be recognized as Dad's granddaughter is not a concession Linda and Lauren get to sell back to her. His expression hardened again, but the strain beneath it had become visible. You are making this personal. They made it personal when they used the word adopted, as proof that Lisa could be removed. Law is not built on feelings. Neither is an adoption decree. That stopped him. I stood and returned the decree to my bag. Elliot remained by the window. What happens next? I asked. He looked at the settlement, then at the closed door behind me. I need until tomorrow morning. To revise the offer? To decide what I am prepared to say. I wanted to ask whether Lauren had paid him, whether he still held the amendment, whether he had already crossed the line. Claire's warning returned before the questions reached my mouth. I had not come to extract a confession. I had come to make certain he understood that silence would not protect him. I will proceed as if you have chosen them, I said. That may be wise. It was not an answer. I left the building without knowing whether I had reached his conscience or merely warned him to hide his tracks more carefully. Over the next 2 days, Claire received no call from Elliot. Harbor sent formal notice that the document verification conference would take place Friday morning. The notice listed Elliot as custodian of records, not as counsel for the trust. Claire read the wording twice and told me it might mean something or nothing. Jordan advised that Lisa should not attend. Lisa objected, saying the meeting concerned her name and her future. I told her I understood, but I would not place her in a room where adults expected to measure her reaction. You still get to decide what I can handle, she said. For this meeting, yes. That is my responsibility as your mother. Jordan will protect your legal voice, and I will tell you what happens without changing it to make myself look better. She did not agree, but she stopped arguing. Thursday night, I reviewed the documents Claire wanted me to bring. I prepared myself for Elliot to place the 2017 trust on the table and say it was the only valid document. I prepared myself for Linda to call me ungrateful, for Paul to ask me to save Lauren, and for Lauren to smile, as if money had restored the natural order of the world. At 10:43, my phone lit up with a message from my sister. Bring a pen Friday. This ends then. 1 week after my father's funeral, I entered Harbor Fiduciary Trust Company, carrying the pen Lauren had told me to bring. The conference room sat behind 2 secured doors on the 7th floor of a limestone office building in downtown Riverton. There were no family photographs, no polished mahogany desk, and no comforting view of the riverfront. Only a long gray table, a wall-mounted screen, and a row of sealed file boxes marked with Harbor inventory numbers. Claire sat beside me. Across the table were Linda, Paul, and Lauren, accompanied by an attorney I had never met. Lauren wore a cream suit and the expression of someone arriving to collect the outcome she had already purchased. Lisa was at school. Jordan had advised that she not attend, and I had agreed despite the argument it caused between us. I did not want my daughter sitting in a room where adults waited to see how much pain her name could produce. At the head of the table sat Harbor's trust officer, Angela Chen, and the company's counsel. 2 empty chairs remained near the door. Lauren glanced at my folder. I hope Claire explained how much today is going to cost you if you refuse to be reasonable. Her new attorney touched her arm. Let us keep personal comments out of the conference. Linda looked toward the door. Where is Elliot? Angela checked the time. Mr. Vance requested permission to attend as the custodian of documents relevant to the trust instruments. He is not appearing as counsel for Harbor. The door opened before Linda could respond. Elliot entered, with a woman carrying a slim black case. He wore the same dark suit I had seen in his office, but the confidence I remembered had been replaced by something more controlled. He did not sit beside Linda or Lauren. He took one of the empty chairs near Harbor's counsel. The woman introduced herself as Rebecca Sloan, ethics counsel for Elliot and his firm. Lauren's smile faded. Why do you need ethics counsel? Elliot opened his briefcase instead of answering. He removed a thick document bound in blue and placed it at the center of the table. I recognized the date printed across the first page. 2017. Linda released a breath. Paul leaned back as though the meeting had already ended. Lauren looked at me and smiled again. There, she said. Now perhaps we can stop pretending. Elliot rested both hands on the table. This is the document Linda Calder and Lauren Bishop instructed me to treat as the controlling trust. The smile remained on Lauren's face for 1 second too long. Her attorney turned toward Elliot. What exactly do you mean by instructed? I mean they retained me after Edmund Langley's death and directed me to present the 2017 trust as the final governing instrument. Linda sat straighter. Because it was the final trust. Elliot looked at her. You knew that statement was false. Lauren's attorney immediately raised one hand. My clients will not respond to accusations made by their former attorney in an informal conference. Former attorney? Lauren asked. Elliot opened a second folder. I terminated the representation and notified your current counsel before this meeting. You never told me that. Your counsel received the notice yesterday afternoon. Lauren turned toward the man beside her. His expression confirmed it. Elliot identified a signed affidavit that he and Rebecca had already submitted under seal to Harbor and the probate division. Under the court's preservation protocol, the conference could use only redacted copies needed to identify the disputed documents. Their final admissibility would be decided later. Harbor's counsel displayed the first redacted exhibit. Lauren's email instructed Elliot to proceed under the 2017 document and avoid reference to the 2025 amendment. The next showed a $75,000 wire from Bishop and Vale Events to his firm, labeled an accelerated estate retainer. That was a legitimate fee, Lauren said. A third exhibit was the draft consulting agreement, promising Elliot $1.5 million after Lauren received her distribution and the Riverfront transaction closed. Paul stared at the number. You said he would receive a success fee, he whispered. Do not say anything, Lauren snapped. The last redacted exhibit was the settlement Elliot had prepared, requiring Lisa to accept money without recognition as a beneficiary and requiring me to release all claims connected to the amendment. Lauren's attorney objected that the communications might be privileged. Rebecca Sloan spoke for the first time. Privilege and permitted disclosure are before the court. Today's limited identification was authorized to preserve the trust instruments and related evidence. Nothing said here decides admissibility or discipline. Linda pointed at Elliot. You are betraying your clients. Elliot's face did not change. I betrayed Edmund first. The words silenced even Lauren. He looked at me only briefly. I accepted the initial payment. I agreed to delay disclosure of the amendment. I drafted the settlement. I had not destroyed the signed original in my custody, submitted the 2017 trust as final, or made a sworn misrepresentation when I withdrew. He did not ask anyone to praise him for stopping. From the bottom of his briefcase, Elliot lifted a second blue-bound document, sealed inside a transparent evidence sleeve. The cover bore the date 2025 and my father's full legal name. Angela Chen entered a code into the table console. A harbor employee brought one of the numbered boxes from the side wall and broke the outer inventory seal in front of both attorneys. Inside was another document sealed in a matching sleeve. Harbor's counsel placed the two originals side by side. The signatures, notarial certificates, and witness pages matched, as did the courier record showing Harbor had received its duplicate months before Dad died. Elliot admitted that he knew Dad had left his office with a second signed original, but the delivery acknowledgement had never been sent to him. He had assumed Dad retained it among his personal papers. Lauren had made the same assumption. She stood so abruptly that her chair struck the wall. "He set us up." Elliot looked at her. "You wrote the instructions. You transferred the money. You drafted the promise of payment before I ever met Megan. You asked me to put things in writing. And you did." Her attorney told her to sit down. She did not. Angela closed the Harbor document again. "This conference does not determine criminal liability, attorney discipline, or final beneficiary distributions. Harbor will petition the probate division for instructions and submit the duplicate original under seal." Linda's voice shook with anger. "What happens to the money in the meantime?" "No distributions will be made," Angela said. "No sale of the core property will proceed. Harbor will preserve the trust assets until the court determines the governing instrument and successor trustee." Paul looked from the sealed amendment to the old trust. "Does that mean we have lost our inheritance?" "No," Angela said. "It means nothing moves until the court rules." Lauren finally sat, but her confidence had vanished. "This is because Megan could not accept that her adopted daughter was never supposed to control our property." I felt the old instinct to defend Lisa by listing every Thursday she had spent with Dad, every name she remembered, and every moment Lauren had missed. I let the instinct pass. "Lisa is not controlling anything," I said. "That is the story you invented because it sounds better than admitting you were afraid of a signed document." Lauren's phone began vibrating against the table. The screen lit with the name Victor Shaw. She silenced the call. It rang again, before her hand moved away. On the third attempt, her attorney turned the phone face down. "Harbor's counsel asked that every Northbridge communication, invoice, contract, and payment record be preserved immediately." Lauren said nothing, but Paul closed his eyes. Claire watched Victor's name flash beneath the edge of Lauren's hand. "Now we know who was waiting," she said quietly. "For Lauren to sell something she never had the right to sell." I told Lisa the truth that afternoon, with Jordan Price sitting at our kitchen table. I did not soften the amount Elliot had accepted, the promise Lauren had made, or the fact that 2 signed copies of Grandpa's amendment had been found. I told her that Harbor had stopped the sale, that no one had lost an inheritance yet, and that the court still had to determine what could legally be used. Then I told her why Victor Shaw had kept calling Lauren. Lisa listened without interrupting until I reached the end. "You let all of them sit in a room and talk about my name while I was at school. Jordan and I agreed that you should not be there. That is not the same as me agreeing." I had prepared myself for her anger at Linda and Lauren. I had not prepared for how much of it would belong to me. "I did not want them watching your face. While Elliot opened those files," I said, "I did not want your reaction turned into another thing they could use. So you protected me by making sure I had no choice." Jordan sat between us without taking sides. "Megan had the right to decide whether you attended an informal conference. You have the right to be angry about that decision. Those 2 things can both be true." Lisa looked at her. "Then what rights do I actually have?" "You have a right to independent advice about the trust. You have a right to tell me what outcome you want. You have a right not to be pressured into a settlement because an adult says it is best for you. Your mother still has the responsibility to protect you from situations she believes may cause harm." "That sounds like everyone gets a right, except me." "It may feel that way," Jordan said. "My job is to make sure it does not become true." Lisa turned back to me. Would you have let me come if I had asked calmly enough? The question struck deeper than I expected. I don't know. That means no. She stood and walked to the window, folding her arms against her chest. I could have defended myself by listing everything I had done since the funeral. Instead, I said the part that was harder. I was afraid they would hurt you, and I made the decision before giving you a real chance to speak. I still believe keeping you out of that room was the safer choice, but I should have told you more before I made it. Lisa did not forgive me then. Jordan did not ask her to. The legal process that followed was slower than the conference had been. The twist in that room had stopped the immediate sale, but it had not explained where the money had gone or how far my family had already committed themselves. Discovery began with documents Elliot had preserved. His file contained a draft agreement between Lauren's company and Northbridge, along with the invoice Claire had found earlier. A court order required Lauren to produce business records, and her bank statements showed a $600,000 wire from Northbridge Urban Partners. The payment had not gone into the trust. It had gone directly to Bishop and Vale Events. Lauren had spent almost all of it before Dad died. Payroll had consumed part of it. Past due vendor claims took more. The rest had gone toward business loans and penalties from 3 failed contracts. She had not used the money for yachts or jewelry. She had used it to keep a failing company alive, which made her desperate without making her innocent. Northbridge confirmed the wire and produced its due diligence file. Linda and Lauren had supplied an excerpt of the 2017 trust, naming them successor co-trustees, a sworn statement claiming no later amendment was in effect, and a personal repayment guarantee. Paul had initialed the side letter acknowledging those representations. The $600,000 was structured as a refundable exclusivity and community relations advance. In return, Linda and Lauren promised that after Dad's death, they would use their expected trustee authority to pursue the sale of Langley Riverfront Holdings. The documents gave Northbridge a claim against Lauren if the promise failed, but they did not bind Dad or the trust. Once the 2025 amendment placed Harbor in control, Linda and Lauren had no authority to deliver the property. Northbridge responded by filing a separate civil action against Lauren and her company to recover the $600,000. Their complaint did not accuse Lisa of anything. It did not even claim the trust owed them the land. It stated that Lauren had accepted payment based on authority she did not possess. I explained all of that to Lisa during another meeting with Jordan. This time, I gave her the choice to read the summary or hear it from us. She chose to read. When she reached the side letter, she stopped at the description of the freight yard as an underutilized riverfront asset. That is what they called it? Yes. Grandpa called it the place that fed 400 families. I remembered Lisa at 12, standing beneath the scratched dispatch plaque, while Dad explained why he had refused to replace it. She had spent years learning the history because she believed knowing it might earn her a place in the family. Linda and Lauren had treated the same history as an obstacle between them and a development deal. They sold it before he was dead, Lisa said. They promised to sell it. They did not have the legal power to complete the sale. That is not what I mean. I understood. They had already decided the stories, the workers, and Dad's wishes were worth less than the money they needed. Lisa pushed the summary away. I want to post everything. Where? Everywhere. The emails, the payment, the agreement. People should know what they did. No. Her chair scraped against the floor. You did not even think about it. I have thought about what public exposure could do to you. Once those documents are online, your name, your adoption, and the amount Grandpa left you become public entertainment. Strangers will decide whether you deserve it. So they get privacy after trying to erase me? I am not protecting their privacy. I am protecting your ability to choose later, when you are not acting from the worst week of your life. You always want me to behave correctly, so adults don't have to feel uncomfortable. The accusation landed because it was not entirely about the internet. Lisa's voice rose. At Grandma's birthday, you told me to ignore it, when they took the family photo without me. At Christmas, You said not to argue when Lauren said the Langley ornaments were only for people born into the family. Every time they did something, you took me home and explained why I should not let it change who I was. I thought I was helping you. You were teaching me to get hurt quietly. Jordan lowered her eyes, giving the words room to remain between us. I wanted to tell Lisa that I had confronted Linda in private, that I had shortened visits and refused invitations. None of it changed the truth she had named. You are right, I said. I asked you to overlook things because I wanted to believe the next gathering might be different. I let you be excluded from photographs. I let them turn traditions into tests. Then I praised you for handling it, maturely, because that was easier than admitting I had brought you back to people who kept hurting you. Lisa's anger did not disappear, but her face changed. I am sorry, I said. Not because this case has become difficult. I am sorry because I made keeping the family together part of your job. My phone vibrated on the table before she answered. Claire had forwarded a new settlement proposal from Linda's attorney. $5 million would be placed in a protected trust for Lisa. $1 million would be paid directly to me. In exchange, I would withdraw my objections, sign a non-disclosure agreement, and support a structure that allowed Linda and Lauren to retain management authority over part of the business. Lisa read the first page, then the second. Her finger stopped beside the line, offering me $1 million. She looked up at me. If you take that million, she asked, who will speak for me and say I was never something they could buy? Lisa's question stayed between us, while the settlement lay open on the kitchen table. If you take that million, she asked again, who will speak for me and say I was never something they could buy? Before I could answer, Jordan closed the document. That is exactly why Megan cannot decide this proposal for you, she said. Lisa looked from Jordan to me. Because they offered Mom money too? Yes. Your mother's interests and yours may still lead to the same decision, but the offer creates a legal conflict. She cannot accept or reject it on your behalf, as though the $1 million does not exist. The explanation should have relieved me. Instead, it exposed something uncomfortable. I had spent years telling myself that every sacrifice I made for Lisa belonged to me alone. Now my family had attached a price to those sacrifices and placed it beside her inheritance, as if motherhood were an invoice they could finally settle. Claire asked Jordan to review the proposal independently. I was allowed to explain what the litigation was costing and how it affected our home, but I was not allowed to speak for Lisa or pressure her toward an outcome. That night, after Jordan left, I sat alone with a notebook and wrote down what $1 million could change. It could replace the savings I had used to hire Claire. It could pay off the mortgage. It could cover college if Lisa's trust became tied up for years. It could pay for therapy, health insurance, and every emergency I had feared since becoming a single parent. For several minutes, I imagined accepting it. That was the part I was least proud of, but pretending otherwise would have made my final decision meaningless. I was tired. I had spent years calculating whether I could reduce my hours without losing health coverage, and whether the roof could survive another winter. $1 million would not only make life easier, it would remove the constant fear that one serious illness could undo everything I had built. Lisa found me at the table after midnight. You are thinking about taking it, she said. I'm thinking about what it could do. She sat across from me. Maybe we should. I looked up. You already used your savings, she continued. You changed jobs because of me. You gave up Daniel. Now you are paying lawyers because Grandpa put my name in something. $5 million is still more than most people ever get. Daniel was not something you took from me. He made his own choice. But you keep paying for choices that involve me. Her voice had lost its anger. That made it harder to hear. I do not want you spending the rest of your life proving I was worth it, she said. I reached across the table, and this time she let me take her hand. You are not a debt I am carrying, I said. You are my daughter. Those are not the same thing. The next afternoon, we met Jordan and Claire in Claire's office. Jordan had reviewed the preliminary valuations and the language of the 2025 amendment. The proposed $5 million is substantially less than 20% of the current estimated trust value, she explained. It may be even further below the value of Lisa's interest if the riverfront property appreciates. Lisa frowned. So they are offering me less and asking Mom to take money for helping them. They are offering certainty, Jordan said. But they also want a non-disclosure agreement, withdrawal of the trust challenge, and continued management authority for Linda and Lauren. Which means they still do not have to admit the amendment controls. That is correct, Jordan said. Claire turned to me. The $1 million payment creates the clearest conflict. You need to decide what you want to do with that portion before Jordan can evaluate the rest without your interests clouding the process. I had brought a signed letter. I placed it on the desk and slid it toward Claire. I reject every dollar offered directly to me. Lisa stared at me. You did that already? I wrote it this morning. You should have told me. You are right. I should have. I had made another protective decision without including Lisa. Good intentions did not make the omission respectful. I am not deciding what happens to your share, I said. Jordan will make recommendations based on your legal interests, and you will tell her what matters to you. I am only removing the price they placed on my cooperation. Lisa looked at the letter for a long time. I do not want $5 million if it means they keep control. Jordan nodded. Then I will not recommend the proposal. She drafted a counteroffer that afternoon. It required Linda and Lauren to recognize the 2025 amendment, accept Harbor as sole successor trustee, and preserve Lisa's full 20% interest in the protected subtrust. There would be no non-disclosure clause concealing the attempted fraud. The proposal also required all communications about the litigation to go through counsel. Linda and Lauren could not call, text, or visit Lisa to pressure her about settlement. Jordan explained that this was a settlement boundary, not a restraining order. It did not declare them dangerous or prevent all future contact. It prevented them from using access to a minor beneficiary as a negotiating tool. Claire sent the counteroffer before 5. My mother called me 11 minutes later. I let it ring once, before answering on speaker with Claire listening. You have destroyed this family, Linda said without greeting me. No. You turned your father's death into a public legal battle. You brought strangers into private matters. You refused enough money to secure Lisa's entire future. I refused money offered to me in exchange for helping you deny her rights. She would still receive $5 million. And you would still control the business. Lauren would still avoid admitting what she did. You would still get to tell everyone Lisa was paid out of generosity, instead of recognized under Dad's final amendment. Linda's breathing sharpened. You care more about punishing us than protecting your daughter. This family was not destroyed when I refused your settlement. It was destroyed when you decided there should be a price for erasing a child. She ended the call. 2 days later, Claire learned that Elliot's firm had placed him on administrative leave. The disciplinary authority had opened a review, but no final decision had been made. His cooperation had not restored his position or erased the money he accepted. Northbridge also filed a separate civil complaint against Lauren and Bishop and Vale Events, seeking repayment of the $600,000. Their dispute would proceed independently from the trust case. Lauren rejected Jordan's counteroffer in full. Her new attorney demanded an evidentiary hearing on the validity of the amendment, Harbor's appointment, and the authority Linda and Lauren claimed under the 2017 trust. Claire read the notice aloud, while Lisa sat beside me. The probate division had set the hearing for November 2026. This time, no one asked Lisa to accept a smaller place in exchange for peace. The court would have to decide which document controlled, but the more important choice had already been made. My daughter's place in our family was no longer available for negotiation. By the time we entered the probate division in November, 8 months had passed since Dad's funeral. The courtroom was smaller than I had imagined, with pale wood benches, 2 counsel tables, and no audience beyond the people whose names had filled our filings for months. Lisa sat beside Jordan, not beside me. That arrangement had hurt the first time I saw it on the hearing plan, but I understood it now. I was her mother. Jordan was there to make certain the court heard Lisa's interests, without filtering them through my fear, my anger, or the $1 million my family had once offered me. Linda and Paul sat behind Lauren's attorney. Lauren wore navy and held herself with the polished stillness she used when cameras were nearby, though there were none in the room. Elliot sat alone near the witness area, with his own counsel. He was not representing anyone. For the first time since Dad died, every person's role had been stated honestly. The judge began by narrowing the questions. She was not deciding whether Lauren had committed a crime, whether Northbridge deserved repayment, or what professional discipline Elliot should receive. She would determine whether the 2025 amendment had been executed properly, whether Harbor was Dad's lawful successor trustee, whether Linda and Lauren held any management authority, and who should bear the costs created by the dispute. Harbor's counsel opened a sealed evidence box and presented the duplicate original stored in its vault. Elliot's duplicate was placed beside it. The pages, signatures, witness certificates, and notarial seals matched. Harbor then produced the custodial acknowledgement Dad had placed in my blue folder, along with the courier record showing the document had entered its vault months before his death. Linda's attorney suggested the amendment might have been the product of confusion or pressure. The argument did not last long. One of the two witnesses who had watched Dad sign testified that he had read every page, corrected a misspelled property description, and asked why Harbor's Special Assets Committee required a second appraisal before any sale. The notary confirmed he knew where he was, what he owned, and exactly whom he was replacing as successor trustee. No doctor appeared to claim sudden incapacity. No medical record showed that Dad had been unable to understand the document. The challenge was not built on evidence that he had lost his mind. It was built on my family's refusal to accept what he had chosen while fully in possession of it. Elliot was called after lunch. He walked to the witness stand without looking at Lauren. Under oath, he admitted receiving $75,000 from Bishop and Vale Events. He admitted agreeing to delay disclosure of the amendment and drafting a settlement designed to make Lisa waive any claim without being recognized as a beneficiary. "Did you believe the 2025 amendment existed?" Harbor's counsel asked. "Yes." "Did you possess a signed duplicate original?" "Yes." "Before Megan Calder came to your office, did you know Harbor had received the second signed original?" "No. I knew Edmund left with it, but Harbor's acknowledgement was never sent to me." "Did you destroy the original in your custody?" "No." "Did you file the 2017 trust with the court as the final instrument?" "No." "Why not?" Elliot looked toward the judge. "Because before I crossed that line, Megan Calder came to my office and made it impossible for me to keep calling what I was doing a family settlement." He did not describe himself as brave. He said he had already accepted money and prepared to mislead Harbor. He explained that he consulted ethics counsel the following morning, withdrew from representing Linda and Lauren, preserved the records, and reported his own conduct. Lauren's attorney rose for cross-examination. His questions tried to turn Elliot into the sole architect of the plan. Had he suggested using the old trust? Had he drafted the language? Had he asked for instructions in writing? Elliot admitted drafting documents and asking Lauren to confirm details. Then Harbor's counsel introduced the email Lauren had sent before my meeting with him. "Use the 2017 trust. Do not disclose the amendment. Once the riverfront closes, your consulting payment will be protected." The draft consulting agreement followed. It promised him $1.5 million from Lauren's expected distribution after the sale. Lauren leaned toward her attorney and whispered too loudly, "He told me how to structure it." The judge looked up. "Miss Bishop, you will communicate through counsel." Paul testified next. He appeared older than he had at the funeral. When asked about the Northbridge side letter, he first said he had not understood the legal details. "Did you know Linda and Lauren had accepted money?" Claire asked. "Yes." Did you know they expected to control the trust after Edmund's death? Yes. Did you know Lisa's name appeared in a later amendment? His shoulders lowered. Linda told me Edmund had changed it. What did you do? Paul stared at his hands. Nothing. Lauren's company was failing. I thought if I stayed out of it, they would work something out. His silence had always arrived disguised as helplessness. Under oath, there was nowhere left for it to hide. When Claire called me, she asked only what mattered. I described the funeral, the kitchen door, and the words I had heard, without adding Elliot's response, because I had not heard one. Then she showed me the settlement offering Lisa $5 million and me $1 million. Did you accept the payment offered to you? No. Why? Because if I took money tied to Lisa surrendering her rights, my interests would become part of the pressure placed on her. I wanted Jordan to evaluate Lisa's position without anyone arguing that I had sold my cooperation. Lauren watched me with open contempt. I understood then that she had never believed I would refuse. Her plan depended not only on Elliot having a price, but on everyone having one. Jordan asked permission for Lisa to make a brief statement. The judge allowed it. Lisa stood beside her attorney. She did not explain her adoption, recite Grandpa's history, or prove she had earned anything. I am not asking them to love me, she said. I am asking them to stop profiting from pretending I was never here. She sat before Linda could look away. Late that afternoon, the judge announced a bench ruling on the core questions. The 2025 amendment was valid. Harbor was the sole successor trustee. Linda and Lauren had no authority to manage or sell trust property, and Lisa's 20% interest would remain in her protected subtrust. The Northbridge side letter did not bind the trust because its signers never possessed the authority they had promised. The judge reserved the exact fee allocation for a written order, stating that the evidence supported a later finding of bad faith conduct. No one was arrested. No inheritance vanished by magic. The Northbridge lawsuit would continue separately, and Elliot's professional discipline belonged to another proceeding. The court had done something narrower and more important. It had identified the real document and refused to let my family profit from hiding it. As we stood to leave, Lauren looked past me at Lisa, with a hatred so direct that I stepped into her line of sight. You did this, she said. No, I replied. Lisa did not take your power by existing. You lost it through the emails, agreements, and payments you chose to sign. Outside the courthouse, Linda caught up with us near the stone steps. I hope you are satisfied, she said to Lisa. You won. Lisa turned toward her. Months earlier, she might have listed every Thursday with Grandpa or every Langley story she knew. This time, she offered no evidence. No, she said. I stopped taking your test. Before we reached the parking lot, Angela Chen called Claire. Harbor would keep the freight yard under professional management, order a new independent appraisal, and reject any rushed sale, while it evaluated the property under Dad's actual instructions. For the first time, the future of the yard would be decided by what the trust required, not by what my family believed they could get away with. The ruling did not repair our family. It only ended the lie that Linda and Lauren had the right to decide whether Lisa belonged in it. The consequences arrived slowly, through separate proceedings that did not resemble the dramatic collapse Lauren had once imagined for everyone except herself. There were no police waiting outside the courthouse, and no single order that erased her inheritance. Instead, every promise she had made began demanding payment. In January 2027, Northbridge obtained a consent judgment against Lauren and Bishop and Vale Events. She had to repay the $600,000 with interest and legal costs. A lien attached to part of her personal property and any future trust distribution payable after Harbor calculated the court-ordered charges. Lauren said she had taken the money to save jobs, but desperation did not create authority. Her company entered a repayment plan, and vendors and clients stopped accepting explanations that blamed me, Lisa, or Elliot. Linda still received the inheritance Dad had left her. The court did not replace his judgment with a punishment it invented afterward. Harbor deducted the share of legal expenses and surcharge attributed to her bad faith conduct, then administered what remained under the amendment. She called that theft. Claire called it accountability. Paul had no share in Dad's trust, so the court took nothing from him. He kept his house, retirement savings, and the quiet life he had protected. What he lost was the right to call himself an innocent bystander. He wrote that he had never wanted Lisa hurt. I believed him, but wanting no harm while helping the people causing it was not neutrality. He had read the side letter, known about Northbridge's payment, and chosen silence because speaking would cost him comfort. Elliot's disciplinary case lasted longer than the trust hearing. He returned the $75,000, lost his position at the firm, and entered a consent discipline agreement rather than force a public hearing over facts he had already admitted. His law license was suspended for 18 months. Claire forwarded a short apology from him after the order became final. I accepted money to help your family treat Lisa's legal identity as a negotiable obstacle. Stopping before the final fraud did not erase what I agreed to do. I am sorry. I read it twice. Then I saved it with the other case documents and did not respond. Forgiveness was not another form waiting for my signature. Elliot had chosen to stop, and that choice mattered. So did the choice he had made before it. He would have to live with both without asking Lisa or me to decide which one defined him. Under the final court order, Linda and Lauren could not contact Lisa directly about the trust, the litigation, or any distribution. Every communication on those subjects had to go through counsel. Beyond that legal boundary, I set my own. They were not invited to our home. They could not call Lisa to apologize, explain, or ask her to help repair the family. I told Linda that any future relationship would require time, changed behavior, and Lisa's willing participation. An inheritance did not give them access to her, and remorse expressed after losing control did not create an emergency she had to answer. Linda accused me of using Lisa as punishment. I told her I was no longer using Lisa as a bridge. By June, Harbor completed a new independent appraisal of Langley Riverfront Holdings. The zoning changes Dad had suspected were approved, increasing the value of the freight yard and surrounding property substantially beyond Northbridge's offer. Harbor did not rush to sell. Its Special Assets Committee approved a supervised operating plan that kept the warehouses open, reviewed the leases, and funded overdue repairs. The decision was not based on nostalgia. It was based on the fact that the property produced income and had become more valuable while Lauren was trying to sell it cheaply. Lisa did not receive a check equal to 20% of $33 million. Her interest remained in the protected subtrust Dad had created. Until she turned 25, Harbor could authorize distributions for education, health care, and other reasonable needs. Jordan explained each provision to her in language that did not make adulthood sound like a prize waiting behind a locked door. When Harbor sent the first annual statement, Lisa placed it on the table between us. "Are you going to use any of this to pay yourself back?" she asked. "For what?" "For changing jobs, the lawyers, everything. The trust is yours. My decision to become your mother was mine. You spent $10,000 because of me. I spent it because adults were trying to violate your rights. That still involved me." I folded the statement and returned it to her. "I will not turn loving you into a bill that your inheritance has to settle." Lisa looked down, and for a moment I saw the 7-year-old who had once kept her backpack beside the bed because permanent was only a word adults used until life became inconvenient. Then she nodded and carried the statement upstairs. Harbor held a memorial gathering at the freight yard near the end of June. It was not a family ceremony. Retired drivers, warehouse workers, dispatchers, and office staff brought photographs, route books, and stories about Dad. Someone set out coffee in dented metal thermoses because Dad had always claimed expensive coffee made people complain more. Linda and Lauren did not attend. Lisa wore the old Navy freight yard cap. She had grown since the funeral, and the brim no longer slipped toward her eyebrow. I watched her move among people who greeted her by name without pausing to explain how she was related to Edmund. Near the dispatch office, Walter Bell tapped a framed photograph of the company's first long-distance shipment. "Your grandpa drove that truck to Pittsburgh himself," he told a small group. "February of 1974, during the worst snowstorm Ohio had seen in 20 years. Lisa tilted her head. A year earlier, she would have corrected him immediately, then glanced toward Linda or Lauren to see whether knowing the answer had earned her anything. This time, she smiled. "It was Cleveland," she said. Marlene Tate rerouted the Pittsburgh load because the interstate was closed. Grandpa spent the next 30 years telling the story as if it had been his idea. Walter laughed. "That sounds more accurate." The others moved closer and asked Lisa to tell the rest. She did. She described Marlene using 3 payphones to redirect the drivers, Dad refusing to admit he had ignored the weather report and the scratched dispatch plaque he kept because it reminded him who had actually saved the shipment. Lisa did not perform the story like evidence. She did not look toward the entrance to see who had heard her or whether anyone believed she had earned the right to speak. Later, when the crowd had moved toward the old loading docks, Lisa and I remained beside the photograph. "Mom," she said, "did Grandpa really think of me as his granddaughter, or was he trying to make me feel better? I did not produce a letter, a recording, or another legal document. Do you remember how he introduced you to Walter the first time?" Lisa thought for a moment. "He said, 'This is my granddaughter Lisa. She thinks I remember half of this place wrong.' He never said adopted granddaughter. He never stopped to explain why you counted. He said your name and kept talking because, to him, there was nothing unusual that needed defending." Lisa touched the edge of the freight yard cap. The trust protected what he left her. It had never created the place she already held. Behind us, Walter called out that someone had confused the year the East Warehouse roof collapsed. Lisa turned toward the group. "It was 1986, she said. And Grandpa ignored the inspection report for 3 months. The retired workers laughed and made room for her to continue. Lisa walked into the circle without looking back for permission, then began telling the part of the family history she had actually lived.